offer is made. But what seals the deal? Let's talk about the yes that makes it real. Hi, I'm Ashik Chandani and this is Logical Lens, where we connect to people one basic at a time. Today we are decoding the acceptance. So let's get started easily, simply and logically.
What is acceptance? Generally, when the person to whom an offer is made agrees to the offer completely, it becomes an acceptance. For example, A says to B, I'll sell you my bike for rupees 10,000, and B replies, I agree. That's acceptance. Legal definition under Section 2, Clause B of the Indian Contract Act 1872 states it when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Essentials of a valid acceptance. First, acceptance must be communicated. Acceptance is not valid unless it is conveyed to the offerer. Silence does not constitute acceptance. Case law Feldhaus versus Bindley, where silence could not be treated as acceptance. Example: if A offers to sell a book and B says silent, no contract is formed. Second, acceptance must be absolute, unqualified, and must match the offer. Acceptance must be a yes to everything in the offer, no changes and no modification. Case law Hyde versus Wrench. A counter offer cancels the original offer. For example, A offers to sell at rupees 1000. B says, I agree, but will pay rupees 900. This is not a valid acceptance. Third, mode of communication must match the offer. If the offer specifies a method of acceptance, it must be followed. Case law Allison versus Henshaw, where acceptance sent by a wrong mode was invalid. For example, if A says to accept a thing by email and B replies by post, it may not be a valid acceptance. Fourth, acceptance must be made before the offer lapse. Once the offer lapses due to time or condition, acceptance has no value. For example, A offers to collect the file till Monday 5 pm. B accepts it at 6 pm. Not valid. Fifth, acceptance must be made before the revocation. If an offer is revoked before it's accepted, the acceptance is ineffective. Under Section 6 of Indian Contract Act, there are 5 modes of revocation. First, failure of condition. Second, delay by not accepted in time. Third, counter offer made. Fourth, death or insanity of the offerer before acceptance. And fifth, valid revocation communicated. Case laws Adams versus Lenzel, where acceptance via post is invalid when posted. Second, Dixon versus Dodds, where revocation valid if communicated. Third, Henthorn versus Fraser, postal rule of acceptance applies when reasonable. For example, A revokes his offer before B accepts, not valid acceptance. B accepts after offerer's death, void. So here's a quick recap. Acceptance is where a contract truly begins. It must be clear, timely, and match the offer. No surprises, just certainty.
We have now got both the sides of the handshake, the offer and the acceptance. See you in the next video. Till then, keep learning and stay curious with Logical Lens.